the last sentence at para 54, such order also contains a default clause in the case of non-compliance of the directions contained therein. So, everything is being monitored by the Supreme Court, and in para 56, in view of the directions contained in the order of 17th April, it would be safe to infer that the Honorable Supreme Court is still in ceasing of non-compliance of the direction. Therefore, the division bench is also is of the view that the Honorable Supreme Court is in ceasing over the matter. Therefore, assuming for argument's sake, that the writ petitioners have a cause to interject the framing of the scheme or implementation of the scheme, my respectful submission is, when the Supreme Court is in ceasing over the matter, and even going by Article 144 of the Constitution, but as the Supreme Court said, in the judgment which I have handed up, the parties should approach the Honorable Supreme Court. And waitlisted candidates were before the Supreme Court. It's not that they were strangers in the Supreme Court proceeding or before the High Court. Therefore, these are primarily my submissions, and no argument has been made that the state is legislatively powerless to frame this scheme. Because 162 says that the executive powers extend to the extent of legislative powers. So no submission has been made that the state is powerless to legislate on this topic. Of course, it cannot be, because Article 41 has been referred to. Rightly or wrongly, it has been referred to. Therefore, in the absence of any submission that the scheme or the legislation is ex facie unconstitutional, but in my very respectful submission, it doesn't call for any interim order, provided my points of demur are not accepted by the court. Therefore, in order to pray for an interim order, one has to show that the legislation or the executive order is ex facie unconstitutional. But that no submission has been made. The submission is that Supreme Court order is sought to be bypassed. And when the Supreme Court has taken note of that in such a case, the Supreme Court is capable enough to take care of its order to be complied with or violated, or to act in aid or acting divorce aid of the Supreme Court. The Supreme Court will take care of that. And we have two more sentences, One is, a number of review applications are pending before the Honorable Supreme Court. And number two is, the scheme itself is, interim in nature. But, may I place, those portions? Mr. Bhattacharya has placed those, but please have a look to, page 70. Please take the last recital at page 71. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families of non-teaching staff in Group C, Group D categories until the final adjudication of the review petitions or appropriate application by the Honorable Supreme Court. Then, my lord, your lordship may kindly take, my lord, the page 72, paragraph 6 of the scheme. First is, my lord, an eligible non-teaching staff in Group C, Group D belonging to a distressed family shall be entitled to, etc., as livelihood support for his or her distressed family due to sudden unemployment and on humanitarian grounds with effect from so and so and whose salary has been discontinued. The benefit shall be discontinued upon occurrence of so and so, so and so. Any of the following, whichever is applicable or occurs earlier. Of which, my lord, item number III is, my lord, conclusion of the Supreme Court proceeding. Yes, and 5 is, my lord, on securing some other livelihood. Therefore, my lord, the scheme itself is, my lord, interim in nature. Scheme refers to the Supreme Court review petition. Scheme again says that it will come to an end once the Supreme Court takes a final call on the review applications or whatever are pending.
Tell me one thing.
Yes.
The amount has been fixed at rupees
20 and
25,000.
25, yes.
20 and 25,000.
Right.
How did you fix up this figure?
But I think it is for the C, it is.
So the salary amount you've taken as the base rate or something.
But on this, right now, I'm not in a position to assist you.
And how many candidates' jobs were set at naught by the order of the Supreme Court? Who will be the beneficiaries? The figure?
C and D.
And page 71,
yes, ma'am.
The third recital,
yes, ma'am,
mentions about a similar incident in the past.
Yes.
What are such similar incidents in the past where the financial benefit has been granted
well,
to?
there has been a lot of instances, may not be for relating to employment. To my knowledge, say for example, my lord, puja donations.
No, those are separate.
Yes,
those
no,
are
but these
separate.
are because 282, my lord, the attention of the court has been drawn to 282. Therefore, my lord, I am saying, my lord, these are all, my lord, come, my lord, under different heads from the consolidated fund, and my lord, different separate account numbers are required to be, my lord, maintained. And there's another judgment where right now, my lord, I don't recall, where, my lord, our High Court has held in regard to the expenditure from the consolidated fund. It is not for a judicial review by a writ court. I'll get that judgment because I was possibly, my lord, addressing the division bench on that. In a PIL, my lord, that was held.
Regarding the
financial expenditure.
Honorarium granted to the
Very many was there. Very
to the
many was there.
Muslim priests or something.
Yes, yes, yes.
There is
No.
one order,
Yes, yes.
right? But tell me, so you are not aware as to why this 25,000 has
25
and the assistance that you will be giving to these people, will these people give anything in return, or they'll sit at home and they'll earn the money?
My lord, here, my lord, because of, as the scheme says, because of sudden loss of livelihood.
That means somebody will stay at home and you will go on paying the money till the Supreme Court decides an issue. And how long will the issue be said to be pending before a Supreme Court? Because one after another review petitions will come. There will be no end. You cannot stop anybody from filing a review application.
That is for the Supreme Court to consider how long will the Supreme Court will entertain.
And no, your petition says, no, your petition says it will continue till the matter is pending.
No, still, my lord, this review applications, my lord.
So one after another review applications will come.
No, my lord, please have a look to my lord.
Second paragraph, filed review petitions before the Supreme Court. Central School Service Commission has filed review petition. Right.
No, it's only the state government, the first recital. Please have a look at page 70.
Yes.
The state government, along with the School Service Commission, has filed respective review petitions before the Supreme Court.
Yes.
Yes. So it is only the review applications which has been filed by the state and commission, which is taken note of in this scheme.
No, but then what will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Yes. Yes.
And to candidates whom the Supreme Court has specifically used the...
May I say this? Yes, I got your lordship's point. My first response would be, that at the instance of the writ petitioners, with respect, kindly do not take me amiss. Possibly, this point cannot be raised by the petitioners. That if I am not getting, why is he getting?
No, he is not getting. He is waitlisted. No question of it.
If he or the petitioners over here cannot get, then the petitioners does not have a cause to pursue before this court.
So you want somebody who were there in the Supreme Court to come here and challenge this? Who could be the, according to you, the challengers to this scheme?
May I say this, today, we are concerned about the writ petitioners. But if the writ petitioners either have a right or they don't have a right. If they do not have a right, then whether tomorrow somebody will come or somebody comes at my liking is something different. If they do not have a right today, in my very respectful submission, this petition cannot be
maintainable. All right.
Entertained. Because, your lordships have held,
yes,
mandamus is, for infringement of an established right.
Anything in reply?
No, 1995. 1995. যেটা ও রিলাই করলো
99.
The deepest of respect, learned advocate, probably.
The first demurrer was locus standi. It is not a pill, it's a writ petition.
This writ petition by a person who was a candidate. After cancellation of all appointment method, all persons come to the same footing. There you cannot make a classification. That's the first point for a writ petitioner, which comes under Article 14. I am not, therefore the locus standi petitioner cannot be questioned at all.
Very well.
Secondly, one important aspect which you wanted to raise kindly takes up 1999 5 SCC. I have not cited judgment, but if necessary, there are judgments, I will cite it. But let me rely on his own judgment, which is relied upon. First of all, this has no 141 application. Kindly first
144.
No, 1999 5 Supreme Court cases, page 733 does not decide any law which has binding nature to this court under Article 141. What does the court say? Let us see. May I just place it? Paragraph 4. We are rather concerned to note that the writ petition number such and such has been entertained by the Lucknow bench of the Allahabad High Court. That writ petition is directed, kindly see, against an auction sale of house number such and such, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court has noticed in the interim order that auction was being conducted under the orders of this court, and the matter concerning auction of the house was pending in this court. Therefore, the question of amity of judicial discipline comes. In our case, this is a new cause of action. You prepare a scheme after the judgments have become a concluded effect. Mere filing of review application does not legally entitle somebody to say that the
list is pending.
Only after the review notices are issued, and the Lordship knows, as so from my experience, I can tell you, Lordship, the Supreme Court review applications are not hard. This is decided by the honorable judges in the chamber. That's why they use this method of filing MA applications, and which have been repeatedly dismissed by the Supreme Court. That indicates the Supreme Court has reached its final conclusion. After that, this scheme, Article 162 does not empower you, I have argued this, to negate a judgment of the Supreme Court in any manner. The judgment declared by a court can only be changed by way of a legislation removing the foundation of the judgment. That is the settled principle. I don't have to argue. Even in this court, we had got the Cooperative Societies Act ultra vires declared. Then they passed a legislation taking out the grounds on which this was declarative ultra vires and passed another law, which is also under challenge. That's a different thing. Therefore, that is the settled law. Therefore, 162 does not empower you to legislate in the form of executive action to negate a Supreme Court judgment or even negate a High Court judgment. And this scheme is specifically maintained for the persons who have been found to be corruptly appointed. Can the state, in any form, giving in the name of relief, support corruption? This is the first question. The second question was that not only they have been found to be corrupted, this direction of the High Court to upheld by Supreme Court that they have to return the benefit of money which they have earned so long. And instead of getting the money returned from them, you are trying to support them out of public fund. This is the question of the constitutional morality again comes in. And in this context, Lord, I would like to cite one of the decision of the Supreme Court where the then Chief Minister of UP, Mr. Mayawati,
106. (106)
2012 8 SCC 106. Here below, the CBI started an investigation saying that the Supreme Court directed. The petition was filed. From that, it went up to the Supreme Court. Supreme Court says, entire thing is quashed. Because you cannot take, in the name of Supreme Court, start doing something which is not under the order of the Supreme Court. This is the basic principle of this judgment. I just kindly place before Lordship the relevant portions.
Exactly. সেটা বলুন।
2000 আর লিখে রাখবো ওর কাছে 2012 8 SCC page 106. After discussing everything in detail, now the Supreme Court says 41, kindly come to paragraph 41. We finally conclude that anything beyond the Taj Corridor matter was not the subject matter of reference before the Taj Corridor bench, that is the Supreme Court bench. Since the order dated 18 September 2003 does not contain any specific direction regarding lodging of FIR in the matter of disproportionate assets case against the petitioner, CBI is not justified in proceeding with FIR number so and so. In view of the above discussions, we are satisfied that CBI exceeded its jurisdiction in lodging an FIR in absence of any direction from this court in the order dated so and so or in any subsequent orders. And then ultimately squashed. Here, my lord, I have been placing repeated orders of the Supreme Court saying, no, we are not interfering 3rd April. And by repeated application, as it is also mentioned in the scheme, the review applications filed by the SSC and in future it might be filed. You are adopting very unfortunate tactics to waste public fund to protect the corrupt people. That everybody has jurisdiction, Milord, and because the Reed Court, where Milord, the fairness of the administrative action, Article 14 is very important.
Page 71.
71, kindly turn to page 71. And my lord has noticed it, that's why he was referring to it.
And whereas second last line writers.
And page 70, and whereas the scheme aims to provide interim relief by of livelihood support and social security. Livelihood support, social security under Article 41 does not remain to a particular group. On humanitarian grounds, to the aforesaid distressed families of non-teaching staff in Group C and Group D categories until the final adjudication of the review petition and appropriate application filed before the Supreme Court or any other further petition has been filed. Twice attempt was made. And again, will I say there is no review application pending for consideration. Mere filing with the registry does not entail consideration by the court. In that background, Lord, I would logically stay the entire scheme.
এটা একবার দেখি এটা একবার আমার কি মনে হয়?
সেটা বলে দিলাম তো।
না, স্যার, একবার দেখি jurisdiction।
You know, my juniors insisting me just to point out to your lordship paragraph 9
Of
of the petition, how will his locus is maintained.
Subparagraph।
এই তো আর কিছু মনে রয়েছে। তারপর জয় কালী। আমি দেখাতে চাইছিলাম আমি লোকাস বলে দিলাম তো তারপরে কোন দেখাবো।
very well.
But only one factual correction, because in reply, I am not supposed to say anything. Milord, the submission made by Mr. Bhattacharya that they have to return the salary, but that is, Milord, factually not correct. Kindly have a look to page para 46, page 60,
বলা ছিল। আচ্ছা,
45 and 46.
মিস করেছি।
টেন্টেড যারা তারা দেবেন, যারা
However, Milord, candidates who are already employed need not be asked to refund.
These are for the teachers. The scheme is for non-teaching staff.
না না স্যার এটা বলে দিন ফটমোট।
46 does not, Milord, make any distinction between group C, group D and teachers.
স্যার নট
আরে
স্পেসিফিক।
খোঁজকে পড়তে দাও না, এত ছটফট করো কেন?
Those who are already employed need not be asked to refund.
Yes.
Right.
Yes.
So you are not giving money to the candidates who are already employed. You are giving money to the candidates who have been terminated.
No, no. But my submission is, Mr. Bhattacharya in reply submitted that
Yes.
Supreme Court
Refund.
had directed refund.
Yes.
That, Milord,
But paragraph 45 says
no.
they should be required to refund any salaries received. Then
But 46, Milord, does not make any distinction between C, D, or Milord teachers.
please.
Very well. Very well. You are lucky.
Whatever the Supreme Court has said, the Supreme Court has said in the order. Whatever.
But one more thing, Milord.
Yes.
Mr. Bhattacharya submitted that filing of a review application does not mean that the Supreme Court is
In CC of the matter.
number one, Milord. The division bench has said that the Supreme Court is in CC over the matter.
Yes, yes, you
And number
submitted
two,
that.
Milord, there is a judgment of Justice Rumapal. Milord, I don't remember, Milord, the page was 555. That's why I remember the page number. Where, Milord, in the context of a contempt application, Milord, our court held that once something is filed in the department, the court or the matter becomes sub judice before the court. Then, Milord, the court may allow it, may dismiss it, whatever it is. But Milord, once it is filed in the department, the matter becomes sub judice. If requirement, I can give that
No,
judgment.
that
But over here, Milord, our division bench in the context of this matter has said
That
it
was
is in
incorrect. That was in respect of limitation of contempt application. That since it is filed, limitation will not run.
Yes, but so yes,
তো ওইটা ঠিক বলেছো, লিমিটেশন ছিল কন্টেম্পটে 1 বছরের মধ্যে অর্ডার ছিল বলে ফাইল করলে পরে ধরে।
and Milord, salary possibly, Milord,
Anyway,
the salary amount was much higher, Milord, I am told, than Milord 20,000 or 25,000.
that is
So these people will be receiving either 20 or 25 sitting at home.
basic.
With
Sitting at
Milord,
home.
if tomorrow, Milord, the Supreme Court dismisses the review application, matter ends over there.
Till the Supreme Court dismisses, the persons
that
will
is
be
not-
paid.
That is expressed in the Milord the
Scheme itself.
scheme itself. I cannot, Milord, make any submission contrary to that.
And whether similar type of schemes are extended or thought of by the state in respect of so many unemployed candidates?
No, the Milord,
Only in respect of the candidates whose
unemployed,
orders,
yes.
whose appointments have been set at
The
not by the
Supreme Court,
Supreme.
Milord,
Very
the
well.
Supreme Court can take care of that, Milord.
No, no, you are the state. You will take care. Supreme Court is not
But
framing
Milord,
the
when,
scheme.
Milord, I have raised, Milord, a legal issue that when it is,
Hmm.
Milord, concerning the Supreme Court and in response to the
Yes,
submission
yes, I followed it.
that the Supreme Court's order is being subverted, but my submission is, Milord, it has to go before the Supreme Court.
ছয় বছর হয়ে গেছে।
Hmm.
Hearing concluded, CAV.
I'm grateful.
Affidavit of service is taken on record. Sorry.
Similar matter. One of the similar matter is filed, my lord. That WP, my junior mentioned today morning, was a similar matter.
All right.
Mr. Bhattacharya,
But then the locus standi, I do not know whether.
same. They
No,
participate in the selection
May
process.
I kindly know that this is a very bad practice with respect to my learned friend.
No, is
When one matter is moved, after the hearing is concluded, slips are given that similar matters have been filed.
I have no problem.
Are you aware of the writ petition? Not
But
stop.
it is served. Yes, it is.
Very well. It will appear in the list. Give the number.
Whatever your
Next.
Lord decides on this will guide the field.
No, whether they are also similarly placed or not.
Therefore, let them
Tomorrow,
come separately.
it is.
My lord will
ought to
decide
come and
this.
tomorrow, my lord.
Thereafter, my lord,
Yes,
we'll-
yes.
we'll take
It
up.
is ought to come in tomorrow, my lord. My lord, keep it tomorrow, my lord.
You
I
give
will.
the number
Yes, yes, I will.
and serve copy upon the
It is
state.
served. It is served.
All right.
It is served. I just handed over the number. He ought to come tomorrow, my lord. And they participate in this whole proceedings, my lord. Up to Supreme Court. Yes, my lord.
আরে শুক্র বৃহস্পতিবার থাকবে তো
না না কালকে
তো কাল নেই
আমাকে থেকে দিয়ে দিলে আমরা চলে যাবো আমাদেরকে 31 লক্ষকে দিয়ে
Yes, next one, please.
লাভ নেই হবে না
11, who is there? Item 11.
क्यों नहीं वहीं पर ना do you have for the petition
11.
12
Actually, 11 declared in the petition of the dismissed. 12.
both do it do you have for the petition
But for the petition, I also kindly turn to page 20. The show cause I am challenging, knowing full well
for same incident both
why I am before this court. You have kindly seized blood. We had approached this honorable court earlier.
1 minute. Will you represent all the respondents?
72
Yes.
The case might
got the brief at 10:30 PM. Today, my lord, one of the respondents, Elawan and other notation. I have not got the full instruction, my lord. Then my manager place, my lord. So for the prior visit, my lord, I shall have to take instruction, my lord. And for that, my lord, I need, my lord, fortnight time.
কতদিন করো না
10 days, my lord, at least.
ইতিমধ্যে একটা নিয়ে দেবো তাও ঠিক আছে
অর্ডার হয়েছে এখনো কোনো কিছু হয়নি
তাহলে সে ঠিক আছে
that is there. They have not yet suffered any. No steps have been taken.
Very well,
They
because
will not-
no steps have been taken, let them not take steps, let him
No,
take
no,
instruction.
Your lordship will not pass any.
No further steps.
But yes,
What is your apprehension?
Because my apprehension is that earlier they have asked me that you are not taking materials from the Czechoslovakia, which is your consortium parties.
All
You are
right.
doing it here. We said make it India, make it India policy. Therefore, we are doing it on our own. That was good. We have came before Lordship, challenged it while I was trying to get certain interim order. Now they say, why did you do it in your own? First action was
I am not there. That was with regard to the degradation. This is my lord for department from the
The same thing, punishment.
separate cause of action.
And the other earlier matter was appearing today in this item 72. 72.
Department and your lordship will find page 20.
Both these matters
Notice has been, so-called notice has been issued on 30th April 25.
That's true.
And today, my lord, 9th June, nothing has happened. Nothing has happened, my lord. Your lordship can adjourn the matter 10 days.
I don't mind. Let it be adjourned for 10 days. Nothing has happened. Nothing will happen further. It করে দাও।
Any the relief that has been paid for, that amount to one giving for final relief to the writ petition. So Lordship kindly adjourn the matter for 10 days. I will come back.
Please come.
The item 72 is also with that.
Can we take up together?
The earlier matter.
On the prayer of the learned advocate representing the respondents to come ready with instruction in the matter, relist the same on 23rd, 2 weeks time. ঠিক আছে? Any steps taken during the pendency of the writ petition shall abide by the result of the same.
Very good. Deep note.
Services. কেউ একজন গ্রেটফুল বললো প্রার্থনা।
13 Lordship. For not today, Mr. Lordship, I'm for the state respondent.
Worship কিছু করো না।
No, no, কিছু করেনি তো।
Who is the petitioner?
Item 12, my lord.
Declared, we will be followed.
They have not taken it.
Any coercive action?
Item 12.
Nothing has happened. Your Lordship kindly consider.
একটা লাইন লিখে দিন তো, learned advocate appearing for the respondent assures the court
But your
that
Lordship
no
will not,
coercive
if your
step
Lordship
will
will
be taken.
pass your Lordship's order, my lord, I am not.
Taken prior to the next date of hearing.
Yes, yes. that's-
Only till 23rd.
My lord, I am for the petitioner in item number 13, led by Mr. Ornavo Banerjee. He is coming just, my lord, from court number 8.
What is the matter about?
Matter about renewal of passport, my lord.
Renewal of passport.
Yes, my lord.
All right. And what is the ground for non-renewal?
My lord, one email was forwarded to me from the embassy itself that police verification is not clear. Further, they have instructed me to obtain information from the local PS and local DIB office. I have contacted to them many a times, but no information was provided to me and nothing was given to me. Say they just asking me for some time. I have given time, but they have not replied to me. Thereafter,
All right. Let me hear police verification.
For the state respondent Lordship, that the criminal proceeding was
What is the criminal proceeding that is pending? Is it still pending?
It's pending Lordship.
Where?
It's lodged in May, I think Lordship.
Which year?
Lordship?
May which year?
This year.
May?
May, sorry, Lordship. On February, I think there was one complaint was lodged, Lordship. It's in the third para, Lordship. Third para, Lordship. Still pending, Lordship, and we have forwarded the request to the DIB and FRRO. It's also pending. Third para, Lordship.
Finding which
Proceeding is pending under the Foreigners Act. How can the passport be issued?
This is the first time
There is a
I am
passport
not
there.
having anything.
You do
Because
not know?
Lordship will find it's on 20th February 2025. It was stated that your verification report is not clear.
Right.
After that, there was nothing. This is the first time I'm hearing something from
Yes.
their end.
So
At
you
least-
take steps before the competent forum.
We have already mailed, but
No, your mail is not the proper forum.
no.
You
We have
have
already requested them. Lordship, kindly have a look at page 68 for one.
There is a criminal case pending against you, and till such criminal case is pending, the authority will not be in a position to issue any passport in your favor.
But the difficulty is, Lordship, kindly make a direction to that effect.
Which
That
effect?
they should be deciding the issue within a certain period of time.
What issue? It has already been decided. They have said that it cannot be done
But-
during the pen. The law says so.
No, he is outside India at this present moment. He is not in a position to come physically over here until and unless he is handed over the passport. The passport is being given for the extension before the embassy. Until and unless passport is handed over to him and he comes over here for resolving the issue concerned.
kindly, Lordship, appreciate my difficulty.
The address is of here only. He's saying he's reside
Why
outside.
he's residing?
Present at
Present address is here only, Lordship. It's very-
Nolhati Birbhum is the address.
He's working over there. Is the present? Is working over there. That is
Working
the
over
reason
there
why the
means-
passport is in the embassy of in the Bahrain.
Sorry, I didn't follow you. Where the petitioner stays?
Bahrain. Bahrain.
Where the petitioner stays?
Lordship, he is from Bangladesh, Lordship.
No.
Wife is from
No, he's
Bangladesh.
from Bangladesh.
Wife is
So
Bangladesh.
wife is a separate aspect.
Right.
Separate aspect.
Petitioner's permit cannot be, the passport cannot be given because there is a criminal case pending against him. Yes, who are you appearing? FRRO, yes. Right.
She was on visa.
Yes.
India.
Getting married to the petitioner.
She obtained certain documents. Her card and voter's ID card. Subsequently, the conditions were there. The petitioner had statement that she had to surrender, get her name deleted from the voter's ID card. Thereafter, the proceedings were initiated against the petitioner, and petitioner is well aware of that. Kindly see page 66.
Yes,
The
Lord.
Indian said-
This is my writ petition. I have already stated. I have not suppressed anything.
It cannot be done. Please come.
But, at least Lordship kindly there is steps to be taken in this behalf.
What steps?
I have already applied for the renewal of the passport.
Praise for renewal of his passport. Stop. The respondent authority has not renewed the passport of the petitioner on the ground that there is an adverse police report against him. Stop. Paragraph from the instruction forwarded by the officer in charge, Nolhati Police Station, dated 22nd May 2025. It appears that Nolhati PS case number 72/25, dated 14th February 2025, under sections 336 within bracket 3 /336 within bracket 4 /340 within bracket 2 /318 within bracket 4 /49 BNS and 14 of the Foreigners Act is pending against him. Stop. Paragraph. Law does not permit the respondent authority to renew the passport in respect of a resident of India against whom a criminal case is pending. Stop. Paragraph. It will be open for the petitioner to take steps in accordance with law to obtain renewal of the passport. Writ petition stands disposed. Instruction written with the records.
But, if you Lordship kindly allow me to have a copy of the instructions which has been handed over.
Whatever I have mentioned over here is the instruction. So there is no requirement of forwarding further copy to you.
My lord, I am for the petitioner.
Yes.
A appearance চাইছে my lord, a purported report as per direction of your lordship has been handed over to me. My lord, kindly have a look at the report.
Yes.
Kindly have a look. Report file করেছো?
Previous occasion, your lordship report
Yes.
has been
Lordship, kindly have a look at the report. My lord, prior to placing the report, my lord, I am placing, my lord, that I a party.
What is your prayer?
Prayer is, my lord, to include my name. Kindly have a look my prayer.
To include your name.
To supply the information which I have made, my lord,
Right.
in respect of my lord RTI.
Apply information. Where is the 4th July's application?
My lord,
4th July's application?
4th July application of RTI, my lord.
Yes.
Yes, kindly have a look. And pursuant to that application,
Where is that application? What is the information that you seek?
page 39, if your lordship kindly have a look.
Applied for mutation.
My lord, then come 42, page 42.
Yes.
It is written by the SPIO to BLLRO, RTI petition such and such, so and so, district.
Any
so-and-so,
reply given?
Request to give the reply directly to the petitioner.
Any reply given?
No reply given.
So
That
why are
is-
you here? There is an appellate forum. 2 appellate forums. Why are you here?
No, my lord, that's appellate forum, my lord, that may be a bar because of the delay.
Delay. So it is
Since
your
my lord-
delay.
Since
You
my lord,
have
that-
delayed.
No, my
What
lord,
have we done?
direction by the SPIO has given,
No,
and they ought
see,
to have. They ought to have. Why I am putting this question? Why the BLRO sat tight over the matter?
why
In the
it has
content,
done? 13th of May, there is already a report and enough details are specified.
yes, lordship,
If you
kindly
are
have a look to the
aggrieved-
report first page.
If you are aggrieved, take steps.
No, my lord, kindly have a look the report.
Hmm.
A search, last paragraph, a search team has already been formed, headed by a revenue officer to find out the hard copy of mutation case number so and so, miscellaneous case number so and so, through a local order number so and so. On so and so, the search team has submitted a report stating that the hard copy of the above mentioned case are not available in this office. Why not, my lord? Kindly have a look to my, kindly take trouble my writ petition. Then.
Listen, the name of one Akhirul Alam is recorded.
Akhirul Alam
is
is the
not a
petitioner.
party.
No, Akhirul Alam is the petitioner.
No, in that case, the name of Nasiruddin has been recorded.
No, I cannot make him as a party. Kindly see the my writ petition. My lord, kindly see page 38. Kindly have a look.
Your case is that the certain plots of land were recorded in the name of some XYZ. Your query was,
Petition is in my favor.
your query
particular-
was, how was the name of that other person recorded? This is your query, right? Now, if any order is passed, then the same will be behind the back of that person whose name has been recorded.
No, I am at best, my lord, I can pray before your lordship and prayer A.
Prayer A.
Yes, my lord, at page 9. Or my lord, I made a demand notice that can be, my lord.
What demand notice?
Page 43.
Why don't you approach the tribunal and get an order from there?
No, I cannot because my lord, this is their fault. That is why they said it is not in the computer data. Why? When the mutation case is was
Any
there.
record of rights correction, section 50.
Well,
You
yes,
did
yes.
before
I am not
proper
praying for
forum.
record of rights. I am praying prayer A at page 9. Kindly have a look to that.
Yes.
Let that
prayer A.
info for RTI, SPIO said BLRO to supply the
In
information.
respect of his application. August 22, you are delayed. If you continue, stick to prayer A, then I'll dismiss the writ petition. Please come. The petitioner seeks certain information under the Right to Information Act, 2005. Stop. Application under the said act was made by the petitioner in July 2022. Stop. Being aggrieved by the inaction on the part of the authority to provide the subject information, the instant writ petition has been filed by the petitioner in July 2023. Stop. Paragraph. During the course of argument, learned advocate for the respondents has placed on record the report of the Assistant Director and Block Land and Land Reforms Officer, Kaliganj, Nodia, dated 13th of May 2025. The same divulges certain information. Stop. The information may not be enough for the case of the petitioner. Stop. the paragraph, it will be open for the petitioner to approach the competent forum for relief if so advised. The writ petition stands disposed of.
Item number 15.
And my lord, only one line kindly subject to your lordship's correction. My lord, this order will not, my lord, prejudice the other forum. Otherwise, my lord, they
The
say that
prejudice. What is
otherwise
prejudice?
the other forum may say, my lord, the High Court has not entertained your application.
No, entertain your application.
My lord, it may happen, my lord. I crossed this type of, my lord, situation. That is why I
What-
prayed, subject to your lordship's kind consideration. If your lordship so directs, my lord,
একটা জিনিস একটু লিখে নিন তো। It is made clear that the court has not entered into the merits of the prayer of the petitioner.
Right.
And it will be open for the petitioner to approach the competent forum in accordance with law if so advised.
deeply obliged.
My lord, in item
ওগুলো
number 15, I
থাকবে
am for the
কিন্তু আগে যা
respondent
বলেছে
bank,
সেগুলো
my lord.
থাকবে।
In this
I am for
matter, my lord, I have filed my affidavit. In the affidavit, my lord, I have already sought for leave to file supplementary
Page
affidavit.
15, item 15, you have filed affidavit.
I am for the petitioner.
Report on affidavit.
Report on, let me hear the
And my
petitioner.
lord, if required, my lord, I may be permitted to file supplementary affidavit.
Why?
I also mentioned because because it is an old matter of 2018. Matter relates to 2018, belated writ petition filed in the year 2023.
Let
And
me
some
hear,
documents were
let
not there
me
at the
hear
time of
the
filing the
petitioner.
affidavit.
Let me hear.
Only one thing I will explain before your lordship, that it was that matter where the Lok Adalat, where they have approached the bank to pay me certain amount to dispose of the matter.
To
Yes, I have paid on the basis of
account numbers.
my two number. My lord has I got it.
Hmm.
Page 17, my lord. I am placing only page 17 before your lordships.
Yes.
This is their application. No, page 17 of the, not the supplementary affidavit,
Page 17 of the,
writ petition.
yes, page 17 of the writ petition.
That is the application of the bank, my lord.
Yes.
But at the top, my
Two
lord,
account numbers are
two account
mentioned.
number have been placed, and my lord, I am only placing the first paragraph that the opposite party has availed loan from the applicant bank of rupees 1,70,000 plus and the present outstanding in the loan account rupees 1,97,000 and odd and rupees 1,48,817. That was the two accounts that have been placed that we have taken loan. Already from the supplementary affidavit, I have showed that your lordship, we have already paid 8 lakhs of rupees totally. 1,50,000 is a security amount that is deposited with them. 6,50,000 have been paid in both the accounts. Bank has passed an order just the page before it. Sorry, Lok Adalat has passed the order, my lord, that if they have thereafter they have passed the order that we have paid only against one
And not the other.
and not the other. Let them go to the bank and then they can pass. Lok Adalat. Lok Adalat will then clarify it. Let them review, make a review application before the Lok Adalat. Lok Adalat will clear it. Otherwise, they would have to file a writ petition before this honorable court. All on a sudden, they are placing that oh, I have not paid the same. It is a poor man.
May I make my submissions? There are two units. One is Joy Matara and one is Bhai Bhai. Not the two units are not together.
Separate.
Separate. Bhai Bhai was granted a cash credit facility. And Joy Matara was granted a term loan facility.
Are they represented by same person?
Same person, no doubt. My lord, this
same shop.
This cash credit which Bhai Bhai was granted was of 3 lakh, to the tune of 3 lakh. And this
Joy Matara
was 1.70 lakh. That was the amount granted. My lord, kindly sees page 70, that is our application. My lord, kindly sees first paragraph, the opposite parties has availed loan from the applicant bank to the tune of rupees 1,70,000. So it is only with regard to the term loan and rupees dash. That means it is not pertaining to the cash credit. Only to the term loan which Joy Matara was enjoying, not Bhai Bhai.
Prior to this, paragraph 1,
I'm coming.
Let me also understand at the top, 2 account numbers is mentioned.
2 account numbers are mentioned.
DL
means demand loan as a term loan.
Term loan. And OD is cash credit.
Overdraft.
Overdraft amount. Right? So this one minute. Lines number 3 and 4, two figures are mentioned.
Figures are mentioned. Now, my lord, I will show my lord. Kindly turns to my lord, page 16.
No, page 17 only
17,
you
my lord.
stay.
Yes,
The
that
two
is outstanding
figures,
we have stated.
1,09,000 and 1,48,000.
48,000 is with regard to the cash credit.
Why are you bringing in cash credit over here? If you say that it is restricted only to the term loan.
And then I'm coming. Kindly turns to page 16, my lord.
Yes.
At first mentions Joy Matara stationery and Bhai. Both the accounts are mentioned, no doubt. 72,000 was a settled amount, 9,000 was to be paid EMI. And my lord, kindly this is awarded portion. Only Joy Matara, no Bhai. So award was only in respect of Joy Matara.
They should approach before the Lok Adalat.
We have clarified that. Well, kindly sees the page.
They cannot.
Which they have impugned, which they have impugned, my lord. The last annexure.
7 lakhs already have been paid by.
We have inadvertently issued one letter prior to this.
Now they are again striking.
Prior to this, a letter was issued saying that yes, you come and collect your no dues. Both the accounts have been settled. We have issued. But immediately on the next date, the controlling branch wrote to the petitioner and clarified the matter.
No.
In the year 2018, which they are impugning in the year 2023.
But page 19 is there. That bank has said both the accounts you have paid.
We have done. Inadvertently.
Page 19.
Prior to this.
Page 19 is 14th of December.
Yes.
Page 20 is 15th of December.
Yes.
Immediately they say that it is in respect of only one.
Yes.
See, it is better you go to the Lok Adalat and
Yes,
settle all issues.
Get it reviewed. And I will admit it. Let that be set aside now.
Acha. The instant writ petition arises. No, not arises. The writ petition is in furtherance of order passed by the Lok Adalat held on 14th of July 2018 at Durgapur, Bardhaman by bench number 1 in pre-litigation case number 1034/2018. Paragraph. The petitioner asserts that the award passed by the Lok Adalat has been accepted and payment made in terms of the said award. Stop. According to the petitioner, the said award was passed in respect of two loan accounts, being page number 17 এ দেখুন দুটো অ্যাকাউন্ট আছে এদিকে
applied for by the bank themselves.
As mentioned in the application made by the bank before the Lok Adalat. Learned advocate for the bank submits that though both the account numbers are mentioned in the application, but the award was passed in respect of only one account, within bracket term loan account, and not the overdraft/cash credit account. আচ্ছা ক্যাশ ক্রেডিট কেড়ে নিন, ওডিটাই রাখুন, ওভারড্রাফট। Paragraph. The bank has already issued a no due certificate in favor of the certificate in respect of both the loan accounts.
Following the said order.
on 14th of December 1998.
2018.
18. The bank has thereafter, by a communication dated 15th of December 2018, intimated the petitioner that the settlement in the Lok Adalat was in respect of only one account and not the in respect of only one account. Stop. The petitioner is aggrieved by the same. Stop. Paragraph. As the award in question, pursuant to which the no dues certificate was issued by the bank, is কি বললাম?
Is the award in question pursuant to which the no due certificate was issued by the bank?
Was passed by the Lok Adalat. Accordingly, the parties are relegated to the Lok Adalat for any clarification / modification of the order. Date dated 14th of
15th of December.
15th of
December. That may be.
No. 14th of July.
No, 14th of July.
14th July 2018. Read petition stands disposed.
Only one thing. 15th
Yes.
December, the letter given by them, that may be kept in abeyance or set aside. Because that will remain, then it will a problem.
No. Go. Acha. The bank is, however, restrained from taking any coercive step against the petitioner till the issue
is decided.
As of now, there is nothing to be decided till the matter is settled by the clarified by the Lok Adalat. Yes, next.
But this 15/12/2018 will remain. That may be.
They will not take any coercive step.
That is the basis of my clarification, my lord.
Yes.
For the state response.
As per earlier direction by your lordship, the respondent of the case submitted in that report, they mentioned about
What is your prayer in the writ petition?
Yes.
Take the microphone, please.
My lord, I am seeking the deed, mutation order, and other supporting documents of the said land. Mutation order, my lord.
For mutation, why have you approached this court?
May I just indicate in short? Practically, the petitioners applied for a copy of the order with respect to a BLLRO mutation of a particular person. Well, there he sought for certain documents. Well, if your lordship kindly takes up page 21, that was the original application. Page 21 of the writ petition. There, the two things has been sought for, my lord, to provide me the order copy of the concerned officer of in BLLRO, Shingur, with respect to a particular case plot number, such and such, and provide me the supporting documents available on record, such as deed copy and against the above question number 1. Now, my lord, what has happened? After that, he has been provided with immediately on the next page, if your lordship kindly sees, the case numbers and all the details has been provided with respect to that mutation case. But so far as the order is concerned, they have been asked that there is a procedure for applying for the same with and has
Certified
to give
copy.
as a certificate copy. Some amount of fees is required as per the per pages. Well, that's what exactly the report also reveals. Well, they are saying that as per RTI Act is there, nothing can be inconsistent with that, and therefore we are not liable to pay any fees for that. But this is not inconsistent with the Act. Our approach is categorically that it is in consonance with the same, but some.
What is your prayer?
My lord, we are asking in page number 23.
Yes.
We are asking the structure about. We don't know how to pay, so we are asking
You
that.
do not know how to pay. What? You do not know.
But they
You are
didn't.
the legal representative of your client. Why don't you advise your client properly as to how to obtain a certified copy? You have filed a writ petition. What is your prayer? You want certified copy?
My lord.
Apply. You'll get it. Do you want anything more?
My lord, we applied in the first appellate authority.
First appellate authority cannot provide you the certified copy. What is your prayer? You want information?
My lord,
What?
about the said land, the
Information has been provided to you. What more do you want?
my lord, we went to first appellate authority.
Again, why will you go to the first appellate authority? Because you have been provided the information. How are you aggrieved by the information that has been provided? Are you aggrieved? Are you aggrieved by the information?
My lord, we need the information, but they didn't provide us the information.
What information you need?
Information about the land. We want to know the details, mutation
Page
order.
22 is the reply to your RTI application. There are 3 case numbers.
My lord.
And you have been requested to apply for the order sheet with the requisite fees.
My lord.
Do it.
My lord, we didn't pay.
Why did you not pay?
The requisite fees? We want to know the structure. So
Page 28 is the reply.
They replied on after 7 months. My lord, page number 23. We asking the same thing they tell in the report.
By submitting High Court form number 54, they can obtain the certificate copy. Well, that has been obtained.
They replied after.
Why don't you apply for the certified copy? You will get all details from there.
My lord.
Did you file a report?
My lord, yes.
Yes, I see a report is over here.
And the last page of the report, the last 2 pages, my lord, is about that notification. There is a clear procedure that they have to pay some fees, my lord. That is the only issue, and have to apply in a proper.
The petitioner has sought for certain information under the Right to Information Act 2005. Stop. The revenue officer and the SA, PIO, Office of the Blockland and Land Reforms Officer, Shingur Hugli, with a communication dated 27th November 2020, provided the information as sought for by the petitioner. Stop. The mutation case numbers were disclosed. Stop. The petitioner was advised to apply for the order sheet of the mutation cases with the requisite fees. Stop. Instead of making application for obtaining certified copy of the mutation cases, the petitioner proceeded to file a first appeal under the RTI Act. The said appeal was disallowed by the appellate authority, granting liberty to the petitioner to apply afresh, seeking the case records. Stop. Any second appeal preferred or what?
No, after that, the writ petition. According to that is only appeal.
There the only point taken is that one that
The petitioner has thereafter filed the instant writ petition. Stop paragraph. It peruse the report filed by the Blockland and Land Reforms Officer Shingur Hugli, dated 9th April 2025. Stop. It appears that the
the first page of the-
authority
Yes.
has only sought for an application from the petitioner along with the requisite fees for providing the certified copy of the documents sought for. Stop paragraph. It will be open for the petitioner to make proper application for obtaining certified copy of the documents from the authority, subject to payment of the prescribed fee. Disposed. Next.
17, I
By
appeal for the state
application
response.
for the purpose of obtaining payments for the works done. Not by tell you lordship will
Malad,
want to
just act a second. Malad, before you, my learned senior friends takes up the matter, Malad. Malad, on the last occasion, I had submitted a report filed by the secretary. Malad, inadvertently, it was my mistake, Malad. The annexures to that report was not furnished before this honorable court. But I have a fresh copy of the entire set. I have already served them. Malad, may I hand over?
Without annexes.
No, sir, annexures diye party. Sir, eight annexures.
Very well.
Malad, may I have hand over a fresh copy of the report, Malad? Letter copy.
Very well. Let me tell you, lordship, what has happened. There was a work awarded to my client.
No, what happened? You want payment?
Yes.
Why is it not being
But
paid?
lordship, kindly come straightway. This is the maintenance period. Last 4 months, 6 months payment has not been made. Now, Lord, kindly, that's the report of my land friend also. But if your lordship kindly come to page 17 of my writ petition.
But they have given in the report, I can see there is reasons mentioned for non-payment.
Reasons, very peculiar reasons. It's not that the work has not been done. It's not that the work.
But are the reasons under challenge? The reasons are not under challenge.
Intimated to me.
Now you've got to know.
Lord Lordship, kindly come to page 17. What was their stance at that point of time? Now they are altering it because you have come to a writ application. That was the, if your lordship kindly sees that, that's your
Page 17.
page 17.
Yes.
That's the letter of the executive engineer. But may it please for your lordship. The reference above this is to inform you that the package number so-and-so has been completed of DLP, that's a maintenance period, work on 31st March 2022. But last 6 numbers of 5th year's bill has not been paid to the agency named so-and-so due to the systematic error in e-mark system. The all matters have been corresponded with IT nodal officer and NRIDA. The express case is completed as a logged out in e-mark system so that it will be paid in offline. That's what the stance at that point of time. Now, kindly see, it's also noted. It's still now pending for payment in PIO logging in the system. This is submitted for kind information seeking permission from your end. That was the stand at that point of 2022. But they did not pay, they did not reply to my subsequent letters. I moved before the lordship. That what were they doing? That they are not making payment to us. Now that the secretary of the Panchayat department.
Listen, now since they have disclosed the reason, you have to challenge it.
Now kindly looks to the reason. Very peculiar.
Page 3 of my
State will pay you. 4 out of 6 months. 4 will pay you. Certified, but the 4 have not been paid to me.
Due to recurring late submission and thereby violation of the SDB clause. Same reason for both.
If 4 have been condoned, why not 2? Very peculiar stance taken by them. The government is taking this kind of stand. I could appreciate the very bad work
Has
done.
repeatedly delayed in submitting the bills beyond 10 days.
medical
However, the contact has approved the first 4 bills.
Because the chairman was zeal. Medical side was also given to them. That was the reason that there was some delay in submitting the bill.
12 days.
If your lordship now kindly looks to their paragraph.
What was the due date of submission of the bills?
That was what they have said, according to 10th day of succeeding month. The page 2, paragraph 2, though they have not quoted clause.
Yes, but how many days delay was there?
Kindly see this chart. Lord. Initially there were 13 days,
then second was 5 days, then there was 38 days condoned, 7
Oh,
days.
beyond the scheduled time, 12 days. See, this is not a reason for non-payment.
My lord,
3
with
days
regard to
mean-
with regard to the state respondents, my lord, the portal was my lord, suspended. My lord, the portal was not in
this
function.
is not concerned. If the work is done,
My lord, we have saying that they are entitled to the bills, but
Then who is
unfortunately, my lord,
paying?
the department, my lord, kindly sees we have correspondent with the Department of the Government of India.
who are you
My lord,
representing?
my lord, I am representing the state. The department,
to
my lord,
pay?
my lord, at the last page of my report,
Who is to pay?
my lord, the National Rural Infrastructure Development Agency, Ministry of Rural Development. My lord, the portal managed by that.
Who is to pay?
I am to pay. The
Pay.
fund comes from that department, but
report is not
ratification
concerned,
comes from
it's
that
for you.
department.
Pay it. How soon?
My lord, we are ready to pay, my lord, subject to what your lordship passes any order.
Immediate payment.
Because, my lord, we are saying that they are entitled to payment. But because of this
payment
embargo,
the
my lord, we
petitioner-
cannot.
The payment of the petitioner has not been paid allegedly for delayed submission of 2 of the bills. Stop. The first bill was submitted beyond a period of 12 days from the scheduled claim period, and the second bill submitted beyond a period of 3 days from the date from the scheduled claim period. Stop. The bill amount is rupees 3,59,668 each. Stop. The petitioner was intimated that
প্রতিদিনই লাস্ট ম্যাটার ধরা হয় এখানে
আমার
আগেও তো
লাগতেই
দুটো
খারাপ।
লাস্ট ম্যাটার
সব লাগতেই খারাপ।
না এটা ভালো লাগে আর এখন দিন ভালো যাচ্ছে আপনি তো
due to systematic error in choto e marg marg all caps system, the 6th the last 2 bills could not be paid. Stop. The petitioners
Neither 4 have been paid. 6 have not been paid. Not only 2.
last 6 number of the 5th 5 years bill could not be paid. Stop. The respondents admit that the petitioners are entitled to receive the payment. Stop. Paragraph. The respondents are directed to take immediate steps. Now, এই লাইনটা কাটুন, তার আগে লিখুন, the reason for non-payment of the bills of the petitioner cannot be appreciated by the court. Stop. It is the respondents have admitted that the petitioners would be entitled to the payment and intimated the same to the petitioner way back in 2022. Stop. It is high time that the respondents take steps to clear the outstanding dues of the petitioner. Stop. Paragraph. Who will be the appropriate authority upon whom the direction can be passed?
But according to the executive India concern, that is the respondent number 3. 3 and 4 anyway. 3.
The একই repetition আছে।
Repetition. Actually, it should be
the secretary, Panchayat and Rural Development Department is directed to ensure that the payment of the petitioner is positively made by 30th of August 2025. The petition stands disposed of.
Grateful. No,